Please recognize the gentleman from Tennessee, Mr. Desjardins, for 5 minutes.
Thank you, Mr. Chairman, and I thank the panel for being here today. Approximately 2 years ago, the EPA sent a shockwave through the ag community and the business community when they introduced their Waters of the U.S. rule. It's been a major concern and a major topic of discussion whenever I reach out to our Farm Bureau, which I like to announce is the largest Farm Bureau in the country, located in my district in Columbia, whether it was former President Lacey Upchurch or our current President Jeff Aiken. Rarely do I have a conversation when this doesn't come up as a major concern to the farmers and ranchers there in Tennessee and obviously across the country. The impact of this broad expansion of federal jurisdiction well beyond the limits approved by Congress would have enormous impact, as you all know. The rule defines terms like tributary and adjacent in ways that make it nearly impossible for a typical farmer or rancher to know whether specific ditches, ephemeral drains, or low areas at his or her farm will be deemed waters of the U.S. To date, 31 states and many agricultural organizations, including the American Farm Bureau, have filed lawsuits against the WOTUS rule. And thankfully, in October, the Sixth Circuit Court of Appeals issued a temporary stay on this rule, citing that the burden of the WOTUS rule outweighed any harm to the agencies in keeping the status quo. I, along with many of my colleagues on this committee, have joined these groups in calling for the EPA Administrator McCarthy to scrap this regulation and require any similar proposals to be developed only after significant consultation and input from states and local stakeholders, such as you who are here with us today. Before developing any such rule, what does the EPA need to do better to reach out to farmers and to understand their practices? And I'll just go down the panel, starting with Mr. Ebert.
Okay. Thank you for the question. I think EPA does have to sit down with the farmers. And instead of looking at enforcement, let's work together at solving the problems of water quality and water issues. I think that would be the main focus of what we would look at EPA to do. Instead of coming out with a heavy-handed proposal with so much uncertainty of where we're going to farm, how we're going to farm, and the uncertainty of the heavy hammer coming down at the farm level, let's go back and rework and discuss the issues and work forward from there.
Just before we move on, as the president of the Pennsylvania Farm Bureau, what steps are you taking to educate farmers and ranchers about the rule and how to prepare for its impacts?
We've put a lot of information out to our members. Luckily, the stay is in place right now. But there is so much uncertainty of how the rule is going to affect us. So as I stated before, if EPA came in and ruled my farm, a waters of the U.S., I would be left in the dark of what to do next.
Thank you, Mr. Ebert. Ms. English.
Thank you for this question. I think it's helpful to hear what happened when my state president, John Hoblich, and I met with the EPA Ag Liaison a year and a half ago when we were in Washington for a Farm Bureau meeting. And we had specifically requested a meeting to discuss the Waters of the United States rule, which at the time was in development, and what it would mean for Florida agriculture. What specifically we were interested in understanding what EPA wanted to protect and what they felt was not already being protected by the rule. We got into a room that had not just the Ag Liaison, but a virtual panoply of agency people who demanded to know why we were there and then explained to us that they had nothing to explain to us and that we needed to just leave. Florida is a real challenge from a water perspective. We're a wet desert. We go through periods of time where we have 40 inches of rain in 3 months, but we may also go through a period of time of 4 or 5 months where we get a negligible amount of rain. We have a tremendously managed system. Using the language that EPA had published, from our perspective, virtually all of the state became jurisdictional for purposes of Army Corps of Engineers permitting under Section 404. And given the endangered species issues that the state of Florida also has, requires that every single Corps permit, even a nationwide permit, go to consultation with the Fish and Wildlife Service for the protection of these species. Case in point, the Florida bonneted bat, which is newly listed. We don't know what to do to protect it. We don't even know where it likes to live or breed or feed. But we are responsible for generating the data that will help them understand how to develop a mitigation program for it. Right now, if I send a file to the Corps and they put a public notice out, if it has a Florida bonneted bat issue, the earliest a staff person can get to opening the file, not reaching a decision, opening the file and looking at it and asking me if there's additional information is 360 days.
Thank you. My time has expired. Mr. Tillum, perhaps you get a chance to respond in a later questioning.